And so then this fraudster, pretending to be the realtor, would send an email. Now they've already watched how you talk in your emails, realtors. So pretending to be you, they'll write and say, hey Joe, can't wait to see you and the boys at closing tomorrow. Here's the amount of money you need to wire and here's where you wire it. Well, the amount of money may be correct, but where they're wiring is to a fraudster.
Welcome to Speaking of Real Estate. Today we're very fortunate to have Jeff Marks with us. Jeff Marks is a real estate attorney in Jacksonville, Florida. He's a native of Jacksonville, Florida. He graduated from the University of Florida with his undergraduate and his law degree, making him a double gator. He has also been the real estate attorney for NEFAR and Realty Web MLS for over 30 years now. He is one of the finest real estate attorneys that I know. We are very fortunate to have him here. Let's get started, all right? Jeff, thank you for being here today. We really appreciate you spending the time with us. So today we're going to be talking about the top 10 things that a real estate attorney wishes that realtors knew. So we're going to start off with, why is it so important to state marital status in the contract?
It's so important because the Florida Constitution says that you can't sell the home you live in without your spouse. So even if the deed is just in your name, you can't sell that, can't do the deed validly without the spouse. So even if you own property in your own name, Jeremy, and you got married just 2 weeks ago, then the new spouse has to sign the deed with you. It doesn't get the money, doesn't sign the closing statement, doesn't sign other closing documents, just the deed. On the mortgage end, the constitutional provision also says you can't put a mortgage on the property that's going to be your home without your spouse agreeing. So you can buy a property alone, though most people buy it with a spouse, but you could buy it alone, but the non-owning spouse has to sign the mortgage as well, which is his or her consent to the fact that you're putting a mortgage on the property that will be your homestead. So that's been the law for more than 100 years. It's our highest law. It's the Florida Constitution. So that's why in the purchase and sale agreement that NEFAR suggests that you use, that in the first couple of lines we put in bold marital status. We want you to put in the marital status. So there are really only two. You're either married or you're not married. So if you're not married, you could put single or unmarried. If you're married, you put married. And even if you're estranged from your spouse, even if you're legally separated, you're still married. Now we also have that same information called for at the signature space. So a lot of times the buyer won't know the seller's marital status. Certainly they can fill in their own in line 2 and when they sign. But when the offer comes to the seller, the listing agent should insist that the seller fill in their marital status on line 3. That's not a counteroffer. They can just put unmarried or single, or if they're married, then we need to know that the spouse is going to cooperate and sign the deed at closing if it's the homestead property.
And should it be on the listing as well?
Absolutely, because again, if we put it on the listing, then the listing agent has addressed that need early with the seller. So you can say, seller, I see you own it alone, you got married 2 weeks ago, we're going to need your spouse at closing. So if you put in that check box in the listing agreement, then you've addressed that issue early and there'll be no surprise at closing.
Great. Okay, so number 2 here, I have a contract that provides that the buyer accept a copy of the survey. Why is that so important?
It's important that we get a complete survey copy. First of all, the buyer can insist on a new survey if the seller's agreeing to pay it at about $300 for an average subdivision house. Or if the buyer wants to induce the seller to accept their offer, they may say, I'll accept your existing survey. But read the contract carefully, Jeremy. It says it has to show all of the improvements. And at closing, the seller's got to sign an affidavit, say this copy of the survey shows all the improvements. That is the driveways and the buildings and the pools. You know, if it's got a chain link fence, maybe we can fudge a little bit there. That's not a big deal. But also the affidavit has to state, the seller has to say, none of the adjacent properties, my neighbors to the left and right and behind, none of them have added on anything to their property since the date of my survey. Because if they put in a driveway, it could encroach on ours. And if that happened after the survey, we wouldn't know. The other thing is we need the full survey. Some surveyors do a 2-page survey where the signature and the legal description's on the second page. It's not just enough to give us the first page. We've got to have the full legal description, the depiction of the property, and the surveyor's signature. So make sure we get all the pages of the survey copy.
Oh, great. Okay. Number 3 is, I have a request to provide the last 4 digits of the seller's social security number from the settlement agent. When should I provide that information?
Great question. It's important and it's needed because some lenders require that in order to give the settlement agent a payoff letter. So if I'm writing to Bank of America or Wells Fargo or ViStar, sometimes they won't give us the payoff letter, also known as a type of estoppel letter, unless we can furnish the last 4 digits of the, in this case, the seller's social security number. Also, at closing, we have to have the full social security numbers of all the sellers because we have to file a 1099. We couldn't finish the closing. We who are settlement agents cannot finish the closing without the social. So believe it or not, some older people don't know their social security number. So listing agents, you might want to write that down at listing and then destroy that, literally shred it or burn it after the closing. By the way, same goes for the valid ID. We need a driver's license or a military ID or the state ID card. And some people may forget it. The little old man seller may not carry a driver's license, may have a state ID card but doesn't carry it. So the listing agent ought to make a copy of it, take a picture of it, but then at closing, get rid of that copy. You don't want to keep non-public information. I have to keep it, but no realtor should keep that.
Oh, okay. What is a good binder deposit?
Well, that's a question I've been asking for about 30 years, Jeremy. Here's what's important. In our contract, and in most, it says that the seller's only remedy against a buyer who defaults is to keep the binder. Can't sue them for damages, can't sue them to make them buy. So right now it says the only remedy is to keep the binder. So if the binder's a lousy $1,000, that's probably not going to make the seller whole if the buyer defaults. That is, the buyer qualified for the loan and just didn't close. I've had examples of sellers literally crying in my office when we explained to them your only remedy is to keep that. And by the way, seller, the listing agreement says that your realtor gets half of that if they want it, So we recognize that market conditions are important. If a property's been on the market for a long time, then the seller may accept a $1,000 binder or two. But if it's newly listed, why take a lousy binder? Because the bigger the binder, the more security for the seller and the more likely the deal's going to close. Now, of course, buyers would rather pay the smallest binder possible, knowing that if they change their mind. So here's an example. In a contract about 25 years ago, the buyer paid a $2,000 binder on a $250,000 house. That's not a big binder on a $250,000 house. 12 hours after they signed the contract, they called me and said, what happens if we don't buy? I said, wow, what happened? They said, we went over last night, our furniture won't fit in there. I said, well, the only remedy for the seller is to keep your 2,000 binder. They said, fine, tell them we're out. Well, that seller didn't really get hurt. They were only off the market 12 hours. But what if that binder had been 10,000? That binder buyer would have closed and bought new furniture probably. So it's important. Now, in South Florida, they do better than we do in this regard. They typically get binders of 10% of the selling price. Wow. And we almost never see those unless it's a very expensive house. So I would say that in our market, we ought to try to at least get a 2 or 3% binder. Again, if you're the listing agent, I think you have some duty. I know you have a duty to explain to the seller, your only remedy is to keep the binder, and I get half unless my broker will give that up. So that's why it's important.
Okay. Wire fraud. This has been a big topic lately, I know around our office. What can you do to protect yourself and your customers from wire fraud?
This is the big issue, Jeremy. Wire fraud is the big issue. In the typical wire fraud, some criminal would hack into a realtor's email account. They'll be silent, but they'll monitor their transactions pending. And then the day before closing, they break in again and they see what the true figures are if the settlement agent sent an email to the realtor saying, make sure your buyer wires this amount of money, and here are the wire instructions. And so then this fraudster, pretending to be the realtor, would send an email. Now they've already watched how you talk in your emails, realtors. So pretending to be you, they'll write and say, hey Joe, can't wait to see you and the boys at closing tomorrow. Here's the amount of money you need to wire and here's where you wire it. Well, the amount of money may be correct, but where they're wiring is to a fraudster. By the way, if you find that out, your initial call has got to be to your bank. If you can get to the bank within an hour, you may be able to stop that. The second call should be to the FBI in Jacksonville, but the first call needs to be to the bank. Now, how do we prevent it? In the purchase and sale agreement, right above the signature space, in bold and underlined, it warns buyers and sellers about wire fraud risks. And it says that to the buyer, pick up the phone and call the settlement agent and verify that these are really their wire instructions. I hear my receptionist, Karen, all the time verifying wire instructions. There's no reason that the realtor should receive the wire instructions. We should send them, we who do closing should send them directly to the buyer to avoid or try to avoid that. Though somebody could be hacking into my account as well. So all realtors, train your buyers to call the settlement agent, have some comfort that you're really speaking to the settlement agent, quiz them a little bit, say who's the processor, etc., and then verify the wire instructions before you wire any money. So all of us have to be very keen on looking for and stopping wire fraud.
So communicate.
Communicate, and old-fashioned pick up the phone.
Pick up the phone, right? Sage advice right there.
Yeah.
If I am extending the closing date with a NEFAR extension addendum, what else should I do?
Well, I have a copy of that addendum, and I'm going to be able to hold it up and tell you. If you're the buyer's agent, you not only want to extend the closing date, but you probably also want to extend the time for financing.
Yeah.
If you've just extended the closing date and the time for financing is expired, plus our 5-day grace period, then you're going to put the buyer at risk if they don't close. So I'm holding up the extension form. It's a wonderful form. And the first box is to extend the date of closing, and the second box is to extend the loan approval period. So it's right there in front of you. Please check both to protect your buyer. If there's a loan closing, if it's a cash, you would just need the first box. But I have seen where people have neglected to check the second box, and it puts their buyer in default, and they'll lose the binder if they don't close.
Oh, wow.
So it is important.
Sounds very important. All right. Number 7. How are the days counted in the NEFAR contract? I've heard this problem before.
Yeah, so we're dealing with the NEFAR contract, and it says in paragraph 19 that except for the acceptance date, then all other time periods, if they end on a Saturday, Sunday, or a federal holiday, which are the 10 we all know, no surprises, then we go to the next day that is not a Saturday, Sunday, or a federal holiday. So with the date of acceptance, if you put on there, you make the offer on a Friday and you say they've got to accept it by Sunday, then we mean Sunday, but all other time periods to get the loan, to apply for the loan, to get home inspections, to ask for repairs, to close, all of those things would go to the next day if the date turns out to be a Saturday, Sunday, or federal legal holiday. Now, the other thing that's important, Jeremy, is that what is the date of contract? So the date of contract we define in there. It's at the bottom of like the next to the last page. The date of the contract is not just when the seller has signed the buyer's offer, but when they've sent a copy of that back and everybody has a copy. Everybody meaning both realtors, because we have a paragraph that says any notice to an agent for a party is deemed to be notice to the party. So for example, a seller comes in late at 11 p.m., been on a business trip, and she sees the offer on her computer and she prints it and signs it, or signs it with an e-sign and says, you know what, I'll send it to my agent tomorrow morning. I'm going to sleep. Okay. So they send it to the agent tomorrow, and the agent forwards it to the buyer's agent. The date of the contract is tomorrow. It's not when the seller secretly signed. It's when everybody knows they signed and have a physical or an email copy of the contract. So if the date of, if today, for example, was the date of the contract, everybody had a copy today, then tomorrow's day one the way we count, because this contract says days after a certain event. So we would count today as day one. We would count intervening Saturdays, Sundays, and holidays. But if the last day is a Saturday, Sunday, or federal holiday, we go to the next day that is not.
Oh,
yeah.
All right.
Good question.
Good question. What is a pace lien?
A PACE lien, that stands for Property Assessed Clean Energy Financing. And only in Clay County of the NEFAR areas has that been adopted. So the state adopted a program that said if a county or municipality in Florida adopts the PACE program, then an owner of property in that county can finance energy improvements and have it paid by the county and then added into their tax bill and paid over the years. For example, new windows, double pane windows, insulation, solar panels, a new roof would count.
Okay.
But understand this, if a roofer knows that the county's paying the bill, you're probably not getting the best price. And the owners probably don't realize that there's a lien, that property taxes are a lien. And when I last checked about 5-6 months ago, there were about 92 properties in Clay County who had a PACE lien. Now, once that became known, then FHA and Fannie Mae says, we're not going to make any loans on properties unless that PACE lien is paid off. We're not going to let our buyers assume the payments for that. The seller has to pay that off and should price the property accordingly. So in all intents and purposes, those have to be paid off. Now, I haven't had to get a payoff letter yet. I dread it because the payoff letter doesn't come from the county. It comes from this outfit in California. Oh, wow. And then we're being told that we won't see the release for weeks and months after closing. So there's some risk on our part as the settlement agent. But again, Duval County doesn't have the PACE lien program, and St. Johns County doesn't either, but Clay does. So be aware if there's a PACE lien, and the listing agreement mentions this as well as the purchase and sale agreement, the seller's going to have to pay that off at closing.
Okay, great. Is the seller required to fill out the seller's property disclosure form?
Jeremy, there's no particular form that's required. Here's the law. In about 1984, the Florida Supreme Court issued a ruling in the famous case of Johnson versus Davis. That case said that the Supreme Court said it's the law of Florida that where the seller of a home, not investment or business property, but a home, knows of material adverse defects that are not readily observable, they must disclose those to the buyer no later than at contract. So material means substantial. If there was a $20 doorknob not functioning, that would not be substantial. If the driveway was full of cracks, you don't have to disclose that. That's readily observable. But all other things have to be disclosed. The roof leaks, the pool leaks, water enters the house every time it rains. Those have been some of the famous cases that have happened. No particular form, but NEFAR gives the seller a very good multi-page seller disclosure form. It asks a lot of questions to jog the seller's memory. Anything from electrical and plumbing, and even has there been a sinkhole claim? Luckily we don't have many sinkholes in our area. All kinds of things that could be disclosed on there to jog the seller's memory. So while there's no form required, we give a good form. So what happens when a seller, like a Fannie Mae, they won't give one. If it's an REO, real estate owned by a bank, they don't know anything about the house and they won't give one. Sometimes you've got sellers who inherited the property. They don't know much about it. They don't have to fill out the form. They just have to say, here's what we know is what we'll say is a latent defect. They just have to disclose what they know in existence by way of a latent defect. But no particular form, but we give you a good form. That form talks about electrical and plumbing and mechanical and even sinkholes, which we don't have many of, to jog the seller's memory as to what might need to be disclosed.
Okay. The best one, foreign sellers. What do realtors need to know about foreign sellers?
Well, Jeremy, we love our foreign buyers, but when they sell property, Uncle Sam wants the money from profit for the income tax. So we love our Germans, our Canadians, our Israelis, our Argentinians, all of them. But when they buy property, it's not their primary residence. Then when they sell it, if there's a profit, then they have to pay a tax on it. And Uncle Sam recognizes that if you go back to Canada or Argentina or Germany, then we're not going to get the tax money. So in the mid-1990s, they passed the Foreign Investment and Real Property Tax Act. The acronym is FIRPTA. And that puts the burden on the buyer, believe it or not, to withhold money from foreign sellers. And it used to be a flat 10% of the selling price, not the net, but the selling price. And now it's 15% if the selling price is more than, I think, $1 million. So what do we have to know? First, there are two exemptions. The sellers are not considered foreign if they have a green card. So if all the sellers are U.S. citizens or all of them have a green card or some combination, then we don't worry about that. Another exemption is if the buyer is going to live in the property at any time during the next 24 months after closing, then they don't have to withhold from foreign sellers if the price is under $300,000. If it's over 300, you still have to withhold. Now, years ago, I had a closing scheduled in the middle of Friday, the third closing of the day. The Thompsons were the sellers. Who knew they were British until they opened their mouth and had this beautiful British accent. But we couldn't do the closing because it takes some time to do that paperwork. If you've got a foreign seller, then you need to get them to a good CPA or tax lawyer who can do the paperwork. The ones I've worked with charge about $600 or $700 to do all the paperwork. They send it to me and say, Jeff, this is how much money you have to withhold. Send it to us and we'll send it to IRS. But it's that buyer's duty. And in the listing agreement and in the purchase and sale agreement, there's a box to check, is the seller foreign? And so alert the settlement agent early if one or more of your sellers are not U.S. citizens or have a green card, because that can't be dealt with at the last second at the closing, and we're going to have a lot of unhappy people if we don't close. So again, it's important to identify that and see if they're, and you can't tell by the name, Thompson, we know, but some names might alert you and some might not.
Well, if they're Canadian,
If they're Canadian, we're probably not going to know.
All right,
But
right.
you're right.
All right, that's it for today. Thank you for joining us for our very, very first episode of Speaking of Real Estate. We hope this information was useful for you. If you would like to reach out to Jeff, you'd like to use his services, you can give him a call at Ryan Marks in Stromberg. His phone number is 904-262-4242. We appreciate all of your time today. You guys have a wonderful day. Stay tuned for the next one.